Well, hello, everybody. Welcome to our YouTube Live. And I want to thank all of you who submitted questions. And I want to get into the topic in just a second. And I know that the topic may be a little bit heavy. Nobody really likes talking about death, but it's a necessary thing, particularly when you own real estate, to discuss. The plans that we make with our property have huge effects on our loved ones. And so it's important to take some time to think about the unexpected costs that may or may not come as a result of our deaths. And by thinking of these things ahead of time, we're going to put our loved ones in a better position once the time comes for us to leave this earth. So I want to give you a few ideas about these costs and how you think about these things or begin to think about these things. And we're going to start off by talking about the costs that come when you don't do any planning. And then we'll talk about when you have done some planning, what kinds of costs can you expect your family to go through in that process, and in what ways can you plan to limit, if not eliminate, those costs altogether. So, and then we'll get to your questions, and then any questions that come up live, please feel free to send those to me, and I'll do my best to answer every question that comes. Let's get started. So the first and the most pressing cost that you should consider is the cost that no plan will have on your family inevitably. So we deal a lot with individuals who come in who say grandma or grandpa didn't have a plan, didn't leave a will, didn't do anything. And so when they passed away, they left property, and now we don't know what to do about it. Maybe taxes remained unpaid, or maybe somebody just took possession because they felt entitled to it, and now we can't get them out. We don't have the power to do it because grandma or grandpa didn't send title to us. And so we're in a bit of a mess. We don't want to lose the property, but now we're incurring all sorts of family strife and inevitably a lot of cost. And so real dollars and cents are spent when no planning happens and an estate is had to deal with or is left to deal with the remaining family members. Now, that doesn't necessarily mean that things are impossible to resolve, but they don't get resolved easily. So one way that even when a family member has passed on and left no will, left no mechanism for transferring property, one way that can be resolved is with an affidavit of heirship. And so this is the least costly way for someone's heirs to benefit directly after they have died, even though they didn't leave a will. So with two disinterested witnesses, and I'm speaking specifically in the state of Texas, there are different procedures across the country, but specifically in the state of Texas, you get two disinterested witnesses to sign this affidavit and say, we know the family, we knew the deceased, whether he was or she was married or not, and who their children were. And so because we know these things, we can testify to their heirs at law. We also know they didn't have a will, and we know a few other things about their finances. And so after death, if someone left no plan for their stuff, it is possible to transfer title with an affidavit. Now, you're going to have to track down all the heirs and make sure you identify them all properly, and you're going to find these two disinterested witnesses. You don't necessarily need an attorney to help you with this, but it can be helpful to have an attorney draft this for you and guide you through the process. Now, this avoids the probate court, but the probate court is another option for you. So even if someone died without a will, you can seek to administer their estate. And so a person connected to the decedent can potentially serve as the administrator of their estate and have the court monitor the distribution of their assets through the probate process. And so as long as you're within 4 years of the death of the individual, even if they died without a will, their estate can still be distributed through the probate court. It's a a little less direct, and you'll have to go through the what's called intestate distribution. You're probably going to want to consult an attorney about this because it's not intuitive, and you're going to have to follow the estates code even if you're going alone without counsel. So it's helpful to have spoken to someone who is familiar with the process and can guide you through those steps. But even if a family member has passed on without a will, you can go through the probate process and have that estate administered. But now you're talking about additional costs, court costs, legal fees. Certainly if you hire counsel, there are additional costs. And then there may be the ad litem, which is an individual who's there for the unknown heirs that may exist out there. And so you may have to pay additional fees to an ad litem to go and do a thorough search independently to see if there's any other heirs at law that may exist that you otherwise did not find. And so by not having a will and leaving things so open-ended, it makes for more work and a more complicated process of distribution. However, if you do leave a will, you still have probate. And so the will isn't a perfect cost-proof mechanism for transferring property because it's not automatic. It requires that your family members follow what's in the will and then get that recorded and processed through the probate court. So again, the fact that you did make plans may also come with costs. And so you're going to want to prepare for that so that your family is not left unaware of the process. Maybe you've spoken to an attorney who drafted your will, and now you lead your family to that same attorney or that same law firm to carry out the probate process. Now, when you've got a plan in place, it's much easier than when there is no plan and heirs have to be tracked down because maybe everything goes to a single individual or goes to a small group of individuals in accordance with that will. It's a lot cleaner, a lot easier for your executor to go and follow whatever instructions you've left. And so your costs will be limited in that way. But there are still costs that accompany a probate. If you want to get ahead of it, feel free to talk to a probate attorney who can answer these questions for you. Now, the final cost that I want to talk about is the cost that comes with planning. And so to not leave these costs to your family after, it's a really great idea for you to have considered these things and what to do with your property, particularly if you own numerous rental properties, how to handle the distribution of your property or the management of your property after your death is an important thing to consider. Now, you may have an individual who you expect, but have you lined everything up so that once you have passed, they take title or they're able to distribute assets in a way that comports with your wishes or that gives them the liberty to do what's needed to be done at that time without additional steps to take. Here are a few ideas for you to consider. Number one, you could have all of your assets, particularly your rental business assets, placed in a single limited liability company, the LLC solution. And many of you already do this. And if you have an operating agreement that allows you to elect or assign or select new members, one way that you could perpetually keep your property in the name of that LLC is to simply add a certain individual, like a spouse or a child or a business partner, as a member, so that if you pass away, you've already got in your operating agreement for your LLC what happens to your shares. Maybe those specific get passed down to a spouse or a family member or a business partner. Perhaps you have other plans, but all of it is already planned for in your operating agreement. Once you pass away, there's no need to go to probate because the agreement is what it is. And you may just have your LLC going on and the surviving partner or spouse or child simply continues with the LLC. And that's one of the benefits of an LLC is that it doesn't die even when we do. An LLC can go on forever. It can take on new members and it can relieve certain members based on whatever is written in that agreement. those remaining members then have the power to manage and sell or purchase additional property, as are the needs of that LLC. So one really great way is to put your property in an LLC or in a trust. And so lots of people establish trusts for this specific purpose and establish a trustee and a beneficiary so that you can have multiple people who are involved in this, but one person specifically who manages it and another person who is a beneficiary, maybe even after you die, so that your trust agreement sets up that upon your death, the trustee remains in place and keeps doing what the trustee has been doing, but that instead of the money coming to your benefit, now that same money is going to the benefit of a third party. And so all of this is automatic without the need of an intervention from court. And because you've planned for it well, you've limited the cost. Now, of course, you've got upfront costs to set up your LLC or to set up your trust, but it'll be well worth it because of the ease that it'll leave for your loved ones. Of course, we talk about the standard one is the will. And we got a question about whether you need a will if you set up an LLC. I'll get to that in a minute. But a will not only talks about what to do with your real property or your personal property or specific property, it can talk about all of your assets, even those that are unnamed. And so one of the great things about a will is the catch-all provision that says anything I haven't otherwise mentioned goes to this individual or goes to the individuals named above. And so the benefit of a will in all respects is that you can designate specific distribution and then have a catch-all in the event that other people die ahead of you or alongside you, as sometimes occurs with spouses, or they die within a short amount of time, and so are unable to accept, even after a will is probated, a direct share of your distribution. And then finally, one convenient method of transferring or setting up a transfer before you die is to sign a transfer on death deed. I did a video about that recently on my YouTube channel. If you look on the long form content, you'll see that's the latest long form video, a transfer on death deed. And what that does is it establishes a future transfer that will not take effect until after you've died, which means that you get to control that asset throughout your lifetime. If you're renting that property out to a third party, if you're modifying that property, if you decide later that you want to scratch out that beneficiary and put on another beneficiary, you absolutely can do that. As long as you're alive, you have all sorts of latitude with a transfer on death deed. Similar to a will, once you've written a will, you can amend it, you can even scrap it and start over. And that's the beauty of these kinds of documents, is that they're not etched in stone. Up until the day you die, as long as you have capacity, you can amend these documents. And a transfer on death deed is an excellent way to transfer property to an individual after you die, while you maintain control of that property during your lifetime. So if you consider these costs ahead of your inevitable passing, you are going to set your loved ones up to a much smoother transition when it comes to distribution and maintenance of your property. So I hope this was helpful to you in kind of beginning the conversation, if you haven't begun it already, so that when you are, or when your family has to deal with this, they are better prepared because of you and your readiness. So let's get to those questions. So here's the first question. Again, if you have a question for me, please send it to me in the chat and I'll be happy to answer it as best I can. So here we go. Question number one. What if dad died and left everything to mom, and mom had a will, but dad didn't? All right, so let's see if we can keep this straight in our mind. So dad passed away first, and then mom passed away. Mom is the one who did have a will, and she left everything to X, Y, and Z, but dad didn't. Well, like we mentioned before, let's assume that more than 4 years have passed. So probate is not an option for dad. And so what can you do? Well, you can secure an affidavit of heirship for anything, particularly things of title, right? So anything with title that is still in dad's name that cannot otherwise be cleanly transferred from mom through the will. So if both mom and dad owned a property together, sure, you can transfer mom's half of the property through her will. But if dad's half never left, there's no way to move that just based on mom's will. And so the best thing to do is to sign an affidavit or find two disinterested witnesses to get an affidavit of heirship signed so that dad's portion can be transferred over either to mom or to his children, depending on the situation. And every situation is a little bit different, but the default is mom to dad, dad to mom, or spouse to spouse, and then from the spouse, the remaining spouse, distribution to the children when there is no will. In this case, mom could have left everything to a neighbor. She could have left everything to her sister. She could have left everything to one child, but we know that dads would have to follow regular intestate distribution. The basic distribution is deceased spouse to living spouse. Now, in certain situations when the children are from different marriages, the community share that dad held, 50% of the house, would be distributed to the children. And so, again, for a clearer understanding of your situation, you're strongly encouraged to go speak to a probate attorney who can assist you with how that distribution is supposed to look. We help people with heirship affidavits all the time. And sometimes, yes, they're going to handle the will and they're comfortable with that, but they need this issue with dad cleared up first. We can assist them with that. And then the rest of the estate can transfer as planned by mom and her heirs. So, second question, how long does a power of attorney work after someone has passed away? Well, that's an easy question to answer. It doesn't. So, and we get this question a lot too, is, well, mom died back in April, but I still have power of attorney. So I've been handling her accounts and I've been managing her property based on my power of attorney. Well, the power of attorney does not survive the death of the individual. If you have a power of attorney, but the person whose property you're managing or accounts you're managing has passed away, that the power ceases at that point, and you need something else. It would be the intervention of the probate court. Maybe you need letters of administration or letters testamentary based on how the probate court is managing that particular estate. But a power of attorney does not survive the death of an individual and cannot be used beyond the date of their death. So sorry if that's bad news, but you don't want to go transacting on behalf of mom or dad if they have since passed away. That's technically not legal. Okay, and our last question, if I have a transfer on death deed, do I also need a will? And this is a question that I referenced earlier about the catch-all. So let's say you have a transfer on death deed, and at the time you signed it, you owned 3 properties. And then right before your death, you acquired a 4th property and really meant to sign another transfer on death deed, but you didn't. Well, it's a good idea to have a will, because a will would catch anything that otherwise hasn't distributed in accordance with your wishes. If you've got 3 transfers on death deeds and those all transfer, again, without the need for probate, but you've got 1 probate asset left, your family is going to appreciate the fact that you have a will in place. Also, we don't tend to think about certain things like vehicles or other personal property that the family may have serious concerns over or serious desire to go and get. So yeah, a transfer on death deed is good for real property, but you still would need a will, again, for that catch-all provision of anything you may have missed, or in the event of one of the transferees or beneficiaries' deaths, you still want your stuff to go to the people you most intended it to benefit from. And so because of the catch-all provision and because of your own personal property that wouldn't be mentioned in a transfer on death deed, it's helpful to have a will just to make sure that all elements of your estate are well distributed. And so for those of you who hung on all the way to the end, I do want to thank you. I appreciate you joining us on these YouTube Lives. I don't have any additional questions. Didn't see that anything popped up. But again, do want to thank all of you who showed up. And if you do come up with a question, don't hesitate to send it to me. Our email address is info@attorneyeg.com. That's info at ATTORNEYEG, that's me, .com. I look forward to helping out. We have, of course, every Wednesday at 4 o'clock, we'll be doing a YouTube Live, and I look forward to seeing more of you there. And until next time, happy leasing.